Great. Well, hello, everyone. Great to see you today. And as I said, I'm Elise Susie-Watts. I'm the Executive Director of Global Digital Finance. We're a not-for-profit industry association, and we work with industry and regulators to support the development of future-proof regulatory frameworks all across digital finance. And I know the previous panel did touch quite a bit on what's happening in the EU, but we're really going to deep dive into that. And so I'm delighted to be joined by Andrew and Mansi to talk about it. I'll let you guys give a quick intro. Go ahead.
Yeah, thanks very much. My name's Andrew Henderson. I'm a partner in the London office of Goodwin. We're a global law firm, big presence on the West Coast and East Coast states. I've been in financial services for over 25 years, dealing with crypto and its like since about 2017. The bulk of my practice is really focused on advising mainly non-EU firms and investors looking to access the EU. And I also work very closely with colleagues in our Luxembourg and Paris offices. So the perspective we bring may be different to a lot of those, but I think what we've seen are the issues are just as real for those people.
I think a perfect person to have on the panel. Mansi, please.
I'm Mansi Birla. I am working with Gemini. We are a crypto exchange. We're based out of the US, and we have a presence in Asia and in the Europe as well.
Yes, and it's come off the passive list before on it, but the problem is
we offer spot derivatives, staking, and like other innovative products based on crypto. And very excited to be talking about our MiCAR experience here today.
So as you can see, I think the reason that we've got a perfect panel to talk about this and really deep dive on the EU is because you advise a lot of people on how to get into the EU market, and you've actually experienced the various challenges or benefits that come with doing that. So I think it's going to be a really interesting conversation, and we're going to try to talk through a few things in quite a bit of detail. So we'll go through CASP licensing, we're going to go through some of the challenges and discussions that have been had around classification when it comes to various tokens as well as stablecoins. And then we're also going to think about enforcement trends and what that means, because obviously as MiCAR is coming into its implementation stage, we haven't seen tons of enforcement action yet. I know the previous panel touched on it, but of course that is something that is going to be increasing as well as different authorities decide how they want to enact the various pieces of that within their jurisdiction. And so I want to come to you first, Andrew, just to give us a little bit of the lay of the land when it comes to licensing. I know obviously many have drawn parallels between obviously MiCAR and MiFID, and they are meant to be complementary pieces of legislation. But what does that conversation look like when you're advising firms and how to come into the EU? How should we be thinking about this framework?
Yeah, it's a good starting point. And there is so often a tendency to dive into detail and just to forget to pause and take a step back. I think there are a couple of points. The first is not to forget the fact that MiCAR is directly applicable EU regulation. On the one hand, that should bring legal certainty throughout the EU. But the challenge, of course, is that although the standards are set centrally, and not just under the level 1, but if you think about all the level 2 measures and guidance that is given, they are interpreted and enforced at the member state level. And if you want to go and get a license, you don't go to the European Securities and Markets Authority, the European Banking Authority, you go to those national member state authorities. And that's very important. I think we'll unpack those points further. The second point is just to think about the architecture of MiCAR and inspiration, and frankly, copy out for many of its provisions. And so what you, in essence, have is a hybrid piece of law that in the front end, when it deals with the actual offering of tokens, takes its inspiration from the prospectus regulation, a lot of the concepts that arise when you're thinking about the public offer and private placement of securities. You then have the piece really that governs the crypto asset service providers, the CASPs, which draws its inspiration from MiFID, the Market and Financial Instruments Directive, and actually again copies up many of the provisions. For example, concepts around composition of capital. Those coming to for the first time will say this is all new. Those of us who've had the fortune or misfortune of having to deal with this for banking clients, for broker-dealer clients, will say it is all much the same. And just to pause there, a lot of the work that we do is advising investors on taking stakes in these businesses and trying to negotiate the types of rights they'll get under the equity and having to say you're limited because there are these things called regulatory capital constraints on what you can and can't do. So don't try and negotiate hard to get those. And then you have the back end, which again draws its inspiration from the market abuse regulation. So you have this mishmash of common and one would say identifiable principles, but adapted to very unique and dynamic types of instruments. So I think that is important in just framing. A lot of people say, oh, we know all of that, but it's amazing how often that is forgotten. And even when it comes to getting into very basic and dare I say granular advice, that you have to take stock of those things. I would also just mention, particularly for those of you that were listening to the last presentation, that although we are talking about the regulation and the role of regulation and regulators, the determining factors for where businesses will establish themselves aren't just by reference to the size of the market, well, say the sophistication of the regulator, but it also comes down to those basic factors like taxation, like employment law. When we get asked the question, which is the best member state to set up our business in, and people want to talk about MiCAR, we say, well, before we get there, given that it has uniform application, let's think about employment law, let's think about tax. But I think that's also an important point, again, just to remind ourselves of those things.
Yeah, absolutely. And I love a couple of those points you mentioned, and I want to come back to them in a little bit, particularly on the fact that all across the member states, that they do have their own national sovereignty as well in terms of how they enforce it. And that, with no piece of EU legislation is it ever enforced exactly the same across every single member state. That is the point of them being individual jurisdictions. So I think that's a really important point to draw out here.
And one point just to follow that on. When it comes to investor protection, one is dealing with a very political issue. And often it'll be driven by actual experience in a member state. It'll be driven by the priority that politicians have been given that the regulatory authorities have to answer to them. And so that's also important to bear in mind. The other point, and we're probably jumping the guns here, is that when we talk about the degree of receptivity that the authorities will have in a particular member state, that is a very, very important factor. Because one might well say, well, Germany is a large country and a large market, but actually crypto assets may not be that much of a priority, and the result of that, it can be actually quite negative, that you aren't going to get the benefit of the doubt because the authorities will say that our economy doesn't really depend on this, so we can take far stricter views. We are seeing a lot of our clients establishing businesses in Poland, because the perception there is that the regime is properly enforced, but there's more receptivity, people are listening more. We've had other clients talking about wanting to possibly acquire exchanges, including derivatives exchanges, and then one naturally says, well, you should probably be looking to places like Cyprus. And one might say that in more traditional finance, they don't have a great reputation. Same may be true when it comes to Web3 and crypto, but you're probably going to get a better hearing and better treatment and better service from the regulators in a place like that than us.
And I want to come back to that in a minute, but first I want to come to Mansi, and I want you to tell us about, well, what was your experience? So first of all, where are you licensed? And then what was that process like? And also, how do you deal with the various challenges and the requirements, specifically when it comes to, obviously there are a lot with regards to onshoring in the EU, et cetera. So talk us through that journey a little bit.
So we're licensed in Malta, and some of the requirements like onboarding and residency requirements are important levers for regulators as well to ensure, one, that we're not a flight risk, that we're not going to run away with the client money, So these are important levers and important deterrents to bad actors. So we do understand the need for them, and we've worked very closely with the regulators to work on these requirements and sort of marry it to the reality of a global organization, which is, even if you're you've got a lot of money, you'd still want to use your resources to provide the users best execution, the best prices, the best and most innovative products. And you don't want to use that time and money to find an MLRO, to find the talent that is just not available in some smaller jurisdictions, and to be able to handle that kind of volume and to have that kind of sophistication and the right kind of training. So we spent a long time. Recruiting was one of the major challenges. But I do think bottom line remains that the regulators and the operators need to work together to sort of marry the intent of protecting customers with actually the reality of what is available for the operator and what we can actually comply with. So I think it was a learning curve, but I think we finally found a workable solution, and we are licensed in Malta now.
Congratulations. So, and you mentioned obviously best execution, and I know there are a number of other things that people have found challenging and seen differences with that enforcement across various member states. So could you go into that a little bit further and just think about what were some of those discrepancies that you saw when you were looking at various jurisdictions? Were there any other things that were particularly concerning for you and that ultimately led you to have, those kind of good discussions that you mentioned with the regulator where you can actually find a middle ground as to what's achievable? Because I think that's a really important piece here as well, is that the whole point of supervision and building up those relationships with regulators is not obviously to sort of cheat and get around these various compliance requirements, but so that firms can work towards having that culture of compliance, work towards what's feasible, getting the right people in, but these things do take time. So could you talk about that a little bit more?
Right, so supervision has to be led by curiosity about a new technology instead of fear and paranoia. There's been some statements about not allowing non-MiCAR compliant stablecoins. We have to try to understand the technology and where it's headed, and stablecoins are integral infrastructure, not just for crypto, but it is the currency of AI. We are ushering in an era of AI agents, and not just AI. AI is already here and it's iterating very fast. And stablecoin is the integral infrastructure that will help you and me interact with AI. And for regulators to sort of fragment that and not provide enough clarity and sort of fragment and introduce more inefficiencies into a system that already works, which is supposed to be borderless by nature. I think the regulators, like I said, need to lead with curiosity, and we've not had a stablecoin product yet, but that is where I see the most challenge, especially for European markets.
So maybe I can come back to you, Andrew, because I feel like, and I'm sure for anyone who's been following this closely, the stablecoin implementation and potential overlap with existing pieces of EU regulation has been probably one of the most contentious parts of this implementation process. And I know for stablecoin issuers, it's been something that has caused a lot of discussion, but also for businesses who want to use stablecoins. So from a regulatory and legal perspective, can you walk us through what's going wrong with stablecoins at the moment in the EU, and where is all these challenges coming from?
And I think if we take a step back, and I can recall, and I'm sorry he's left, but when I used to work with James, in early days of people coming to us and saying, we've got a great idea, we wanted to use tokens. And you said, well, what you're really looking to do here is to transfer fiat currency from person A to person B, using the technology, but also wanting to somehow wrap that within a token. Mm. And the nature of the service is such that often what is seen as a utility, which is essentially what payments is, very important, probably the most important utility in the financial sector, with this thing called a digital asset, which is often just a piece of information either representing itself or representing something else, you can get, as a matter of practice, a big overlap. and conceptual confusion comes in. And it also then feeds into this broader point, and again, this isn't just unique to Web3 and crypto, around are we providing a financial service or product, or are we providing, I was going to say merely, but actually, or are we providing technology? And the truth is that people have great ideas. They want to use the new technology to allow people to do stuff. So I throw that in because we see this, so we've seen this before, we see it here, and we also see it increasingly in the US, where people are saying, well, this thing called a stable coin, which is essentially a digital representation of money, be that single money or a bundle of money, is a very efficient way of moving that value. And that's the use case, that's the application. And then they find themselves running up against a regime, which, when it comes to stable coins, can't quite make its mind up. As I said earlier, if you look at the architecture of MiCAR, the provisions governing stable coins or asset reference tokens are actually contained at that front end, which is more the kind of public offer of securities piece. But thrown in there is a piece of what is essentially banking law that says, you know, if you're going to essentially market something, there are certain requirements that we require for you, you know, to comply with, to have that properly backed. And again, if we go back to the early days and, you know, the early products offered, say, by the Winklevoss brothers, you know, where people said, well, what is it you're really getting? This is the essence of it. Do you think that you're getting something, a representation of cash that is sitting in a, you know, in a secure bank, or actually are you getting something that just references cash and really comes down to the credit worthiness of the issuer? So it looks more like you know, a debt instrument, a debt security. And the response, one size fits all, from the policymakers under MiCAR is to say, no, we will actually expect you to, you know, be able to not just reference that asset by its name, but actually back it. And to reinforce our oversight of that, we will require you to actually establish your business in the European Union. And that is a big break, certainly for a lot of our clients in the US, saying, well, that's a killer. We simply can't set up the business. And what's more, and we've had recent experience of it, if we have a product that offers an element of stability and really actually offers an element of exchangeability that references, say, US dollars, but isn't backed by US dollars, and we make that crystal clear in our disclosure, we are still at risk of being told, sorry, if you want to offer that product into the EU, notwithstanding what you told people and said this is not backed by dollars, it's backed by another cryptocurrency, you have to set up here and you have to ensure that at least, you know, you hold assets, at least 30% of your assets are actually in whatever that currency is. And they say, well, it doesn't work like that. It's an algorithmic product. It's backed, in this case, by Bitcoin. It's stable and secure, but we are simply excluded by definition, unless you know, the relevant national member states takes a more purposive approach to it. But I think that's the challenge. Again, you have this sort of hybrid piece of law which has sort of shackled all these pieces together. And you said, right, oh, this is the bit that just has to do with cross-border offering. Like we're offering shares and we may limit we offered it, we make disclosure, and they say, no. We're actually saying that the issuer has to come and say, and you say, but that's kind of like bank legislation, isn't it? And they go, oh, yes, but it's a lot easier to control and EU investors will feel a lot safer and more secure. So it's a bit long-winded, but that's part of the problem.
So actually, and I like your framing of this, is actually that we have a kind of multifold problem here, which is that we have the issue of multiple pieces of legacy banking legislation, e-money, PSD2, which is moving to PSD3, and then you also have MiCA, which obviously incorporates kind of cross elements of a lot of these. But then also you have this cross-border capture, where actually some things that may not even want to be a stable coin are being captured under these other pieces of regulation as well because of these onshoring requirements.
Correct. Yeah.
And I think that is, and obviously we have seen many issuers who are able to issue successfully in the EU. This isn't to say that no one can issue there, but there are certainly stringent requirements for that. And I mean, we would need a whole other panel to probably talk about backing asset requirements for stable coins. But I think it's certainly, and I will say in defense of the EU, I can understand why this is important to them. When you think about stable coins as money, they want to make sure that money being used across the EU is not a threat to sovereignty, is not a threat to the euro. We've seen a lot of discussions around digital euro, and so you can understand some of their nervousness, but obviously it can sometimes create real challenges for businesses trying to navigate that landscape as well.
Completely right. And you make an excellent point around an inherent fear. People will say, particularly when people start talking about, central bank digital currencies and the like. And I can see the use case for it. It'll make it easier to settle, on-chain securities transactions and sort of real-world asset transactions. But the other challenge that comes up is that, of course, we act for e-money providers. I followed with great interest, a lot of people say you're a sad person, but the FCA consultation on changes to e-money and safeguarding. And I think one point, it's usually when you talk about what are the things that really matter to regulators and to policymakers, the secure holding of what investors and other users perceive to be their stuff. And you just cast your mind back to the failure of Lehman Brothers in 2008. People say, well, that's not relevant. No, it casts a very long shadow over everything.
As does Libra. That still casts a
correct.
shadow as well.
Yes. Yeah. But the point around e-money is that, again, you actually have more flexible requirements around how things are backed and what safeguarding means, and it's more just a concept around speed of settlement. Yeah. And so somebody says, well, we understand the concept of, same risk, same regulation, but it doesn't quite mesh. But I think it has to do with the fact, and this is part of the challenge with Web3 and with this environment, is that you can move very quickly. You can do things that are innovative, which means they've not been seen before. And the natural inclination of lawmakers is to say, that looks risky.
Yes, and how can we manage this risk?
Correct.
But that brings me to another question I want to come back to, Nancy, is that one thing that we hear talked about a lot, and I'm sure that some of you guys saw the recent news headlines, is regulatory arbitrage. People are very worried about regulatory arbitrage, and you see a lot of times some of the larger member states saying that they're worried about firms setting up in smaller jurisdictions because they think they'll have an easier ride, and because they're worried about, that they're going there to try to arbitrage out of basically stricter requirements and some of these challenges we've been talking about. So I want to come back to you, because when we were having our prep call, you had some interesting views on why actually maybe sometimes it isn't regulatory arbitrage, and from your perspective in working with various regulators. So I'd love to hear your views on that, Ken.
So first, anybody who accuses us of regulatory arbitrage should try to hire in a smaller jurisdiction. It is painful. But coming back, I think one of the less visible reasons for choosing a certain jurisdiction is actually the sophistication of the regulator. We've had so many conversations with so many regulators where we couldn't get across to them what a stablecoin was, what a certain crypto did, how our spot product works, which is the most basic. And then there's derivatives and tokenized equities on top of that. So it is hard to engage with regulators who do not understand the basic underlying technology and how we actually, through our custody infrastructure and through our best execution policies as well, we are trying to give users the highest levels of protection and also are trying to give them the best price for the crypto by not fragmenting liquidity, by not looking at 5 different venues for the price of one security, because those 5 venues, if they're locked out from the global liquidity book, will have very, very high slippage and wide spreads, and that is bad for the user. So in order to have the regulators understand that and work with you on maybe not diluting certain requirements, but sort of staying technology agnostic and sort of seeing what the intent of the law is, and then allowing us to sort of maybe give us like a a pathway to compliance, give us some time to do that and work with the regulator on that, but at least like hit the ground running. And so in order to do that, which is very important for operators because licensing anyway has like months of runway and a lot of money spent, and to realize like a year into the licensing process that jurisdiction is just not going to be workable is bad for attracting new and innovative players, and it's bad for the people because they don't get access to these big companies who've got best practices and years of experience in the certain sector and actually can provide you very innovative products in a very, very safe and compliant manner.
So you would argue actually that it's not always about regulatory arbitrage, but sometimes about regulatory sophistication as well, which is, again, very interesting. And maybe just staying with you on that for a moment then, part of that obviously then comes to enforcement, which I mentioned at the beginning. How do you think that that kind of regulatory sophistication then plays into enforcement actions that are taken as well, and how have you seen that playing out?
Okay, so that would actually bring me back to like the stablecoin point, where if the regulator does not understand how integral stablecoins are to the crypto exchange infrastructure, the crypto capital markets, and then to say that non-MiCAR compliant stablecoins would just not work, means again you're introducing inefficiencies into a market that already works, and you're sort of siloing the EU out of a market that should be global. And then again, you're actually, the users get the short end of the stick because the regulators are too scared to like try to engage and understand a new technology.
Now, I know you have thoughts on this as well. please add them in. And I know that you also have views on MiCA as a cross-EU piece of regulation and what that can do to reduce arbitrage too.
Yeah, and some of this comes back to those opening comments. But I think there can be a mistake, as I said before, to think that it's just in the written word and the standards issued centrally. And I think there's also another point just to bear in mind, and it was reinforced following Brexit. But the increased, well, there's an interesting tension within the European Union at the moment, but certainly the desire for increased centralization of standard setting, more reliance on regulation, more level 2 and 3 guidance, more direction being given by the Commission and by ESMA and the EBA to ensure that certain jurisdictions, and it would be unfair, but mentioning places like Luxembourg, where we have an office, and Ireland, others, for whom financial services is more important, would relax standards in order to entice people from all over the world there. So that is a big driver. But I think you make some excellent points. Local sensibilities become very important. There is a question around sophistication, which often comes down to the question of how many resources a particular regulatory authority wants to devote to. As they might say, we don't see crypto as being that important, but we think it's dangerous, so we want to protect against it, and perhaps less engagement. And I'm talking again in abstract, so I still think that things are playing out. There's also another interesting phenomenon, and a lot of these concepts aren't just particular to crypto and Web3, but if we think about fintech generally, but this idea that as an organization becomes more sophisticated, becomes more institutionalized, it may actually look to a more stringent, if that's the right term, jurisdiction. And an example, and it's in the public domain, is Revolut looking to move its operations from Lithuania to France. And there are other reasons, but certainly what's reported in the press and in the market is that is seen as a sign of maturation, that you actually almost want to subject yourself to a stricter standard. And one of our observations, and this comes more out of colleagues in the US, but is that as crypto becomes more and more mainstream and starts being taken up by more of the large institutions, there is a sense the arbitrage may not actually go down, and bizarrely almost pushes it up. But you still come back to this point that at the coalface, the people who have to make decisions within regulators are human beings with all their individual frailties and fears, particularly of elected politicians. And the outcomes, may not be the ones you look for. The takeaway, perhaps logically, is think very carefully about that when you present business propositions to them, when you seek to explain systems, when you design your own systems. Sometimes one will say, well, do we really need these board minutes or committee minutes because no one's going to read them? You say, perhaps not.
Perhaps they will if you're audited, though.
They look good for regulators and auditors, and I would also mention, as this is lot close to us, investors.
Very true.
Investors.
And I will say, first, as a former regulator, I appreciate you saying that we're real people. That's very nice. But I appreciate that. Most, yeah. But also, I think that, you've touched on a couple of other really important points here, too, which is that, one, this is still a very, very young industry. And I know for a lot of us that are in this room, we probably all care about it quite a lot. But it's also important to remember that it's not the only part of financial services that regulators are regulating and having to think about. And you mentioned, obviously, political tensions, the pressures that they face. Obviously, here in the UK, we know that the FCA can get called in front of Treasury Select for any failings that they're deemed to have not, fulfilled their objectives correctly. And all of those objectives have to be balanced alongside what will be either the division or the individuals who are looking after crypto and digital assets. And so I think you mentioned, obviously, that the industry is still maturing. I think that's true. And I think the regulators will mature as well. And I mean, if you think about, derivatives markets, if you go back a number of years, there weren't very many regulators who were going to be regulating derivatives, if you go back far enough either. So, it's these things that as the market matures, so does the regulator. And I think that's a really important point. But I want to come back to you for one more question before we move on from this topic, which is obviously, I want to get your views on enforcement as well. What enforcement trends do you think that we're going to see in the EU in the future as MiCAR continues to be implemented, probably as part of this maturing process?
I mean, again, I think one needs to go back to first principles. I think the number one fear probably is financial crime, and if there are issues around financial crime, and given perhaps the rather unfair reputation that the industry has with respect to that, I think that's an area to look to. Issues around the enforcement of financial crime are also low-hanging fruit because you can go after people's systems, and we've, even in this country, we've had some fairly high-level enforcement actions, not to do with crypto, but just to do with banks, not implementing systems properly. So I think that whole piece around financial crime and systems is an issue. And then the next one will come down to investor protection. But again, and these are just prognostications, what are the sorts of things that authorities are looking out for? Well, they look out for what's been said in marketing material. In much of what's basic, I was talking this morning something around ESG, which is another area that we cover, and essentially, are you making promises that you can't keep? Are you playing down things? Are you misleading people about actually the status of what they're getting? Is it a thing, or is it just reference the thing, for example? So I think those remain the areas. It's going to be driven, of course, by political considerations and by member state considerations. If there's something that's more universal, of course, you will have pressure from within, but it's softer, it's more political pressure. I think that's the big difference between the European Union and, say, the United States, where actually the central or federal authorities do have real power.
Yeah.
So, but those are general statements.
I think we'll have to reconvene to see what the enforcement trends are next year. But so coming into our kind of closing discussion and looking at future and broader trajectories, and I think we will have time for a couple of questions in a few minutes as well. But maybe coming back to you first, just obviously as we look across the EU, and this question to both of you, I'd be interested to get your views in terms of how MiCAR fits within the broader EU regulatory trajectory, because obviously there's a lot of other moving pieces in the European Union at the moment. I mentioned PSD2 earlier. There's DORA, obviously, which came into force and applies to a lot of crypto firms, despite the fact that everyone always focuses on MiCAR. So what are your thoughts on these kind of broader EU regulatory developments and then the direction of travel for firms?
I think we're still amidst figuring our way through it, and we've had good luck with the regulators so far, and I hope the regulators continue to be as curious and as involved and consultative in their enforcement of these new laws, and we hope to do some good work here.
Great. Your views?
I think a driving factor will be the extent to which Web3 technology, crypto assets, is more integrated with the rest of the financial system. I mean, it's significant that there was a big focus on financial crime. The other big factor was to focus on the exposure which banks had to crypto and make sure that was done. But I think it's great that you mentioned DORA, because that's on. But the concept, again, take 2 steps back, the growth of the importance and focus for international banking regulators on the role of operational risk, realizing that the next financial crisis, such that won't necessarily be caused by banks not knowing what the others have, but by systems breaking down or massive cyber attacks and what have you. So that in turn rode into this question on operational resilience, stress testing, the expansion of jurisdictions into non-regulated sectors, which will be relevant. Often, people might turn around and say, well, the great news is that we're not subject to MiCAR because we're just providing a technology. But you're so significant to the system, including the Web3, because DORA does apply, much as it applies to banks, that you will be subject to some kind of supervisory jurisdiction within the EU. I think that's the piece to watch, just the growth of technology. It's always fashionable to throw in AI, and we do a lot of AI-related work, but our view on AI in financial services, it's not really creating new risks, it's just amplifying or accelerating those. And I think, it's interesting when you think about the roles of things like AI, say, in trading, things have become more quick, et cetera. But yeah, I think as technology is a great facilitator in making, creating a single capital market, in fact, beyond that. But I think those risks and the way risks are addressed and seen to be addressed is going to become essentially important. KYT, know your tech, is
Operational resilience, very important, still at the forefront. I completely agree, and I personally think that DORA is a piece of regulation that is often overlooked outside of the kind of maybe more technical communities, but I think it's one that actually probably should be being discussed just as much as MiCAR.
It shouldn't actually. It's interesting. We had one of our clients is a major crypto infrastructure provider, and their business is just growing, and they don't want to talk about MiCAR. We have this discussion. DORA was the real focus, and the fact that actually with this fantastic technology that they are providing not just to crypto businesses but to main financial institutions, they've been presented with their so-called DORA addenda, and they're having to write up to certain contractual provisions, and we start saying, well, you need to get in the front foot and master those. So central to your day-to-day business, more so than a lot of the kind of MiCAR-related stuff. So.
Very much agree. So last question for both of you before we go to questions. If we were all gathered here next year talking about MiCAR again, which to be honest, we probably will be, what do you think that MiCAR's biggest either success or pitfall will be a year on from now? Nancy, I'll start with you.
I think regulatory clarity and even enforcement across all member states can really make or break EU's place in the global markets for the crypto industry. So I hope the regulators try to understand the technology and work with operators and with all the new products that are coming with the new wave of sort of technological optimism towards crypto that is led by the US and intertwined with what's happening with AI. I really hope that the regulators sort of engage with it, and it's going to be a crucial year, and it can put EU at a very, very central place in the crypto industry if this goes well.
Exciting. What do you think?
Yeah, I think the focus on the relationship with those outside of the European Union, the fact that there's this vast market in the United States, there's more optimism about crypto in the United States, and people come to us and say we really would like to approach users, investors in Europe, and they include the UK and Switzerland. We have to kind of disabuse them of that slightly. But I think just thinking more carefully, and that said, the issue of extraterritoriality, I think MiCAR has probably taken a leaf more out of the GDPR and indeed the DORA book than it has out of say MiFID in that respect, and there is that increase. But I think the hope would be to be a bit more balanced in the assessment of that. I think that's one. And then I think secondly will be, it's an interesting question around regulatory clarity, because the question is, does that mean further standards or rather a refinement of standards? I think being a little clearer about the interrelationship between payments and trying to give those that are regulated under MiCAR a little more credit when it comes to payment services and understanding how those interact. I think those would be my...
I think I would agree with your first one would be on my wish list too. I think that, and Peter Kirstens has said this many times, was that when they first worked on MiCAR, there wasn't anything to make it equivalent to. So why would they have equivalence provisions within it when there weren't many things that they could have worked with? I think that there have been some discussions about how those kind of conversations around reciprocity and deference could be reopened, and I would agree. I think they're really important. But I want to turn to you guys. Any additional questions for our wonderful panelists? I think we've got a hand over here, Emma, and then, I don't know, if I thought I saw another, but I missed it. We've definitely got one over here.
First, just to say it's great to see such an experienced panel. Crypto is such a complex space, and I was curious what you think about the importance of lawyers and regulators understanding technical terminology and aspects.
Nancy, do you want to start with that? You've talked about this a bit.
I think it's been very crucial in our experience, specifically because a lot of the times we had to explain a lot of how our processes internally work, and how that is actually for operational efficiency, and how the custody infrastructure works, and how we actually are working to provide the best levels of security to our users. And even best execution it's highly technical on order book matching, and specifically also and how we work with market makers, how basically the mechanics of how we provide the services that we do. So I think it's very important to have sophisticated regulators who are a bit more tech forward and tech savvy. So, I think it's also a learning process, and we also have to meet them halfway, because they, like the panel discussed, that they have a lot to do. So it's also our job to sort of bring them up to speed, but we've been fortunate with that.
I totally agree with that. I think the industry has a huge responsibility to also be supporting regulators in upskilling. That's why we should be responding to consultations and requests for information. That's why we should be going in and meeting with them, because realistically, they're not operators, so it's not fair to expect them to know all of this at once. But I wanted to ask you to answer kind of the second part of that question, which is about lawyers and talent pool, because you mentioned that being a real challenge. So how do we solve that?
I think that first of all, it's vitally important. Well, this sounds a bit cheesy, doesn't it? For lawyers to listen. We must listen. But there's a broader point. I think what I find interesting, I think the environment in which the lawyers operate is important. I mean, I'm fortunate I work at a firm that has quite a long history dealing with the venture capital generally and technologies. And crypto, in a sense, has been an expansion of that. So actually, it's the approach. It's the combination of being open and actually saying we're going to understand what the stuff does, even if we don't, because we don't. But also actually understanding the environment, understanding that often perfect is the enemy of good. I suppose it's where sometimes private equity is different venture capital is different private equity. But I think it's vitally important to listen. At the same time, I do say to junior lawyers, our brilliant clients are interested in your opinion about their industry, but they aren't coming to learn about their industry from you. They actually want to understand law and regulation. And I come back to my original point, and that is that, understanding the broader context in the existing regulation that has been cobbled together to address crypto. So you must understand and listen, learn, and really be sensitive to how the industry moves and what people want. Don't over-engineer it. I don't know if there are any lawyers here. And I think at the same time that translates back to regulators, because, and this is age-old people saying, oh, these regulators, City of London are meant to have the best in the world, they don't understand. You say, well, hang on, what have you been saying to them? You must understand there's no real upside in them taking a bold interpretation, because their bosses could be hauled before the Treasury Committee. So how do you explain things to them? And I would suggest your starting point actually is their own regulation, their own existing world, as flawed as you may think it is, and being able to go from then to say, this is why this is similar to what's before, but why it's also different, why there isn't the risk. So yeah, I think it works.
I also love that as an answer to the talent question, which is that for firms, you don't need your general counsel to be the most amazing coder. You need them to understand how the technology works and how the regulation interacts with it, but they don't need to be the technologists.
Yeah, but a vitally important role, and this is something that's come up a lot, was way back in the day when we were approached, first ever token issuance, and wonderful founder, and it was all over the place. We're going to fractionalize. And I said, listen, let's just simplify it. You essentially are just a kind of old-fashioned merchant bank. You want to bring together company, the providers of capital, and you're going to use this thing called the blockchain to do it. And we did it. And in the end, it was quite amusing. He said, Andrew, I remember what you said earlier about just simplifying it. And the other thing is the vitally important role for those in the middle office is to ensure that the people who are coding and, who possibly don't like other human beings that much, are able to communicate with the people in charge. And that the people in charge, and we go back to senior manager responsibility, not just an FCA thing, but a company law thing, that if they're ever asked, well, the thing broke down, the operation, the thing broke down, where were you? And they say, the truth is we didn't really understand it. Not a good look. Not a good look. So I think making sure that they can broker that communication piece and say, listen, assume we don't understand, and let's really play that role of, whether it's just in your board packs, but just in explaining stuff to the board so they can say we can make good decisions. I think that communication piece is vital.
Love that. Great question and very comprehensive answer. Do we have one more question? I think we have time for one more if there is any. And if not, massive thank you to my wonderful panelists. Thank you so much, you guys.